Disclaimer. The comments made in this video are intended solely for entertainment purposes and are not intended to harm or offend anyone.
From a woman violating community supervision due to her addiction to drugs,
find it true, grant the motion, and sentence you up to 180 days in the state jail facility.
to another criminal stalking women and trying to use his mental health as an excuse.
All right, so I understand he's bipolar and schizophrenic, according to him. But why does his bipolar and schizophrenia only result in him having issues with women?
Here are 5 moments where Judge Boyd ensures criminals pay for their actions. No excuses allowed. Starting with Ms. Vanessa Garcia, who was caught driving while highly intoxicated with a child under 15. This crime is classified as a serious offense that led to her being placed on community supervision.
And are you Miss Voss? All right, this attorney was appointed to represent you recently. Your attorney has 10 days to prepare to answer for you. Do you have any objections to waiving those 10 days and having the attorney appear for you? Counsel, are you waiving your 10 days?
I am waiving it for 10 days, Your Honor.
And have you had ample opportunity to confer with your client?
I believe so, Your Honor.
All right. Ms. Boss, did you have a chance to review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it? Are you the same Vanessa Garcia Boss who was placed on community supervision in 2023 CR 1969 for the offense of driving while intoxicated with a child under 15 on March 28, 2023 for a term of 2 years? Is that you?
This case here is wild. Why in the world would someone be so irresponsible to the point of driving while intoxicated, especially with a child in the car? She didn't just put herself at risk, but also an innocent child who depended on her for safety.
All right, state.
On or about 22nd day of May 2023 in Bear County, Texas, the defendant has been in there illegally using substance, namely marijuana, in violation of condition number 2. State ways for it in violation.
To violation of condition number 2, how do you plead? True or not true? And counsel, do you have any objections to the state's waivers?
No, Your Honor, no objection.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, and sentence you up to 180 days in the state jail facility? Knowing that, do you still wish to plead true to violation of condition number 2?
There's seriously no excuse for putting a child's life in danger by driving drunk, but then she got sentenced on probation and dared to violate her probation terms.
Court will find violation of condition number 2 true. Is there a proposed agreement?
Yes, Your Honor. Revoke supervision, excessive punishment, and confinement for 1.
Is that the agreement?
That's the agreement, Your Honor.
All right, are you asking the court to follow that agreement? All right, and is that 180 days in the state jail facility?
Yes.
All right.
It's as if this woman doesn't even understand how serious her offense is and does not want to change her behavior.
Are you waiving your right to appeal? All right, the court will find violation of condition number 2 true. The court will grant the motion and the court will sentence you to 180 days in the state jail facility.
She probably thinks the rule doesn't apply to her, so she refused to learn anything from her previous offense.
And probation. Was there any restitution in this case to Mr. Tovar?
Are you asking if it was paid, Judge?
Yes. Okay.
Judge, there was not any restitution actually assessed. It was still to be determined.
All right. All right. Well, since you've been on probation since March, and there's been no restitution requested, the court is not going to order restitution.
Thank you, Your Honor.
The audacity of committing such a reckless crime and still landing herself in court for another after being given leniency in the first place is outrageous.
So, the court will grant the motion as previously stated, 180 days in the state jail facility, give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? I'm also going to request a therapeutic community for her. It doesn't increase the length of time that you're in custody, but if you have any issue, they may be able to help you with that. I don't have the authority to place you in that program. You'll have to request it as well. Do you understand? All right. Good luck to you.
Thank you, Your Honor.
Thank you.
It's frustrating when serious crimes like assault get a second chance, but the offenders refuse to change, just like Paul Zapata, who was initially placed on deferred adjudication for choking a family member. Instead of turning his life around and changing his toxic behavior, he violated his community supervision terms by using marijuana illegally.
2021 CR 7311. State of Texas versus Paul Zapata. Can I have parties announced for the record for the state defense?
Angela Blake.
And are you Paul Castillo Zapata II? All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Are you the same Paul Castillo Zapata II who was placed on deferred adjudication in 2021 CR 7311 for the offense of assault, family choking, strangulation on January 25th, 2023 for a period of 6 years? Is that you?
Getting deferred adjudication for assault by choking is already a gift most offenders don't get. But instead of appreciating it, Paul just threw it away, proving he's just not interested in real rehabilitation at all.
All right, state.
Yes, Your Honor, we're proceeding on violation of condition number 2, that on or about 30th day of June 2023 in Bear County, Texas. The defendant, Paul Castillo Zapata II, did then and there illegally use marijuana in violation of condition number 2.
How do you plead to that? True or not true?
And we are waiving the rest, Your Honor.
Any objections?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 2?
Paul admitted to the violation by pleading true to using marijuana, knowing that it could result in his probation being revoked, a guilty finding, and a sentence of up to 10 years in prison.
May you repeat the question?
Right. Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 2?
I don't want to lie, so.
All right. So you still wish to plead true to violation of condition number 2? I can't hear you. Is that a yes? All right. Is there a proposed agreement?
Yes, Your Honor, there's a proposed agreement to revoke and adjudicate. We're recommending that he be given 2 over 2, Your Honor, and that he also be added for inpatient treatment.
All right. And what are you requesting?
Your Honor, we're also requesting the same to revoke, adjudicate him guilty, sentence him to 2 years TDC, probated for 2 years, and that he attend treatment. He has a request for outpatient treatment, but I've discussed the case with him, Your Honor, and the situation was that he had been involved in outpatient treatment. He was unsuccessfully discharged from the outpatient treatment, and then I guess failed to appear at probation. We would just request again that the court give him treatment, and my client would also like to address the court.
All right. You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right. You can lower your hand, state your name for the record.
Paul Castillo Zapata II.
All right. What would you like to say to the court?
I was just gonna add to for the reset, is just to complete the class, which is ring class.
No, that ship has sailed.
Okay.
All right. Do you want to start by telling the court why you are using marijuana, knowing that I could sentence you to prison for 10 years? Let's start there. Let's start why you are not participating in your outpatient treatment.
Transportation.
No, there's something called the VIA bus. I used to take the VIA bus, so there's no shame in taking the VIA bus. When I took it, I think it was maybe $1 or $2. I'm sure maybe it's gone up to $3. I don't know, but you can take the VIA bus. So transportation, that's no excuse. So why are you testing positive for marijuana?
Smoke.
I'm sorry?
So smoke.
Yeah. And who are you living with?
A friend.
All right. So what is marijuana coming to you? Do they do a DoorDash? How does that work?
It's in the area.
All right. So you were able to find your marijuana, but you can't go to probation. You can't do your outpatient treatment. See, when things are important, you treat it like it's important. So obtaining your marijuana was very important to you.
It was not, but I did.
Paul's audacity to boldly blame violating his probation on transportation issues and his so-called friends is just crazy. The first person to blame here is himself, because it's obvious he's just not interested in being a better person.
No, I mean, it was important because here's the thing. You're looking at 10 years in prison if you smoke marijuana. And guess what you did? You weighed that and you said, 10 years in prison for smoking marijuana. I'm going to go with the marijuana. That's what you did. And then not reporting for your outpatient treatment. Not reporting for my outpatient treatment and blaming it on not having transportation or 10 years in prison. Let me not report for outpatient treatment.
Well, as expected, Judge Boyd didn't buy his dumb excuses and called him out immediately, making it clear Paul chose the wrong path. No one's falling for his attempts to dodge responsibility.
So I'm going to give you a choice. You can either do 3 years at the prison, or either I'm going to keep you on deferred so the full range of punishment is available to the court, and you're going into inpatient treatment. There will be no outpatient treatment for you, and you're going to sit at the jail until they take you to inpatient treatment. So which do you prefer? All right, court is going to deny the motion, alter and amend conditions to include probation. Do you think SATF is best for him or ISF?
Judge, recommendation is for Saturday.
All right, so that will be SATF. Do you have any children? What do you mean not at the moment? What does that mean?
I'm not sure if the friend that I have is pregnant by me or not.
To make matters worse, this guy, who already has a lot to fix in his life, went out, creating even more problems.
So when you say you're not sure if she's pregnant by you or not, is she currently pregnant and you just don't know if you're the father? Okay. So I'm gonna order 100. Oh, there's already 240 hours of community service restitution that was previously ordered. I'm gonna order parenting classes. And do we still have AIDS awareness course? All right. So here's the thing. The reason why I'm suggesting AIDS awareness course. It appears that you are engaging in activities with someone and you don't even know if you could be the father. You know, they have different STDs now, and people would always just think AIDS, well, you know, that'll be with you forever. Herpes, okay, that'll be with me forever, but they have treatment for it. Well, now they have something called super gonorrhea, and there is no treatment for super gonorrhea. You have super gonorrhea, it's like, good luck to you. We have no medication for you. It's resistant against the antibiotics that are now on the market. So you just be walking around with super gonorrhea until you dropped. Oh yeah, but you're not thinking straight. You're just out here having intimate activities with people and smoking marijuana. And now if this child is yours, they're going to have a father who has an assault, family choking, strangulation case and who sits around all day doing marijuana. You had better start making some changes.
Instead of cleaning up his act, he's potentially bringing a child into this mess, which is completely insane and irresponsible of him. I mean, he can't even handle his life, not to talk of another's life.
Probation, is there anything else he needs?
No, Judge, I do want to make you aware there is that AIDS awareness program.
All right, so we're gonna do AIDS awareness, and there's gonna be proof of employment within 30 days of release. When's the last time you worked?
The day I was arrested,
And what were you doing for employment?
I was working at the temp service, for them. I was doing a construction cleanup.
All right, so there's employment within 30 days of release, no employment as a home health care provider with minors. I'm gonna want field visits 1 time per month for 4 months. And I'm gonna want the UA hotline until further notice. Anything else, probation? Is there anything else you need from the court to be successful? All right, we can go off the record. Here's the thing. From here on out, everything you do, you need to ask yourself, could this result in me potentially going to prison for 10 years? If the answer is yes, don't do it. If the answer is maybe, don't do it. This is Texas. According to probation guidelines, I didn't set these rules. The legislature set it. You are not allowed to smoke marijuana while you're on probation. You are not allowed to drink alcohol while you're on probation. You say, alcohol is legal, not while you're on probation. So if you're sitting at your house chilling, you are not to drink alcohol at your house, because if you test positive for alcohol, a motion to revoke is going to be filed. If you test positive for marijuana at your house, a motion to revoke is going to be filed. And these people that you are hanging around with who think it's okay for you to be using marijuana, you need to cut them loose. And you know why? Because they don't care about you. Because they cared about you, they would say, hey man, you know, I know we usually sit back and smoke marijuana, but you're on probation. You're looking at 10 years. We shouldn't be doing this around you. We shouldn't tempt you. If they cared about you, that's what they'd be saying, but they don't. They're like,
While Paul faced the consequences for his probation violations, John Swamy here is charged with 2 counts of endangering his children. John left his children unsupervised, even with one having special needs, while under the influence of drugs.
All right, court is calling 2024 CR 6596, State of Texas versus John Swamy. Hi.
Hi, how are you?
All right. Can I have parties announced for the record for the state? Defense?
Renee Munoz.
And are you Mr. Swamy?
Yes, ma'am.
All right, counsel, have you received all of the discovery? Did you review it with your client?
Yes, Your Honor, that's correct.
Court will find that the state is in compliance with discovery. Mr. Swamy, did you review the document entitled Application for Deferred Adjudication with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yeah.
On both counts?
Yes.
Okay. Did you review court admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand you're charged with the offense of abandoning or endangering a child
Yes, ma'am.
with intent to return in both counts? Right, that's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Indeed, yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge, that's correct.
Mr. Swamy, has anyone threatened you, forced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's no application for community supervision and the state is recommending deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense is at the plea.
Yes, Your Honor.
State is at the plea.
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Judge.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 4 years. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? Then to the offense as charged in count 1, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
To count 2, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
State offers this exhibit 1 with attachments.
No objection.
All right, state, you may be excused. Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney?
Which one you got?
Yes, all people.
Oh, yes.
Again, did you understand you have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
And did you sign the document in all the appropriate places? Court, and did you understand that the state would not be presenting any witnesses at this time, that the court will review states exhibits 1 and attachments and base my decision on sufficiency of the evidence solely based on those stipulations? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
If we may, Your Honor, yes.
All right, anything you wish to say on behalf of your client?
Yes, Your Honor, briefly. I would like to, at this time, take the chance to tender this update letter from the Johnny Morales pretrial bond officer since August 20th, Judge. I showed it to the states. It's him completing successfully inpatient treatment at Lifetime Recovery. So he did do that inpatient facility, Judge, and he's been compliant with aftercare thereafter. Also, Judge, he is undergoing a CPS plan right now as a result of this case. And there are parenting classes that he's been attending and will continue to attend as scheduled, as well as drug testing that he's been compliant with, Judge. So you would ask if the court could take that into consideration, be open to the idea of mirroring some of those things he's doing with CPS. An additional thing, Judge, is that he is indigent, appointed by the Public Defender's Office. He's not currently working. So we'd ask for some leniency in regards to the fines, so he can be successful without worrying too much of the stressful nature of the monetary obligations.
How can someone abandon their children and then expect leniency?
For that reason, being San Antonio is getting a little more expensive. A lot of things are getting more expensive. He's looking to relocate to Sweetwater, Texas, in Nolan County, Judge. Things are a little bit more affordable out there in terms of housing. So we're looking for a potential transfer or report by Zoom, if at all possible. It's my understanding it's in Northeast Texas.
West, but I could be wrong.
Northwest Texas, yes. He's looking to move over there, Judge. But we just wanted to bring those things to the court's attention. He's been sober since March 4th of this year, completed lifetime recovery, and I've noticed an extreme change. And when I just first met him as to now staying off and clean of the drugs, he's very much more clear-headed, and he's telling me he can be successful in this probation. I believe that he can be successful in this probation, Judge. So I'm hoping he won't have any further run-ins where he has to see this or any other courtroom. So
That's why I plan on going to Sweetwater.
All right. I've noticed a change in you as well. So here's my question. With regards to Sweetwater, Texas, who do you know there?
We're getting property out there.
All right, who's we?
Me and my fiance.
All right, how are you getting property out there?
She has a check due to her recently deceased husband.
I'm sorry, what?
She's getting money every month due to her recently deceased.
Through some settlement?
Yes, and we're going actually up to Waco right after court here to go put the down payment.
All right, so what is Child Protective Services saying about this?
I still have to get in contact with them. If they say I can't do it, then I would have to stay here.
All right, and who has physical custody of your children?
The mother of my children's cousin, Ashley Ranzinski. That's the last time I've known about it.
All right, and is this a legal case or is this family-based service? Well,
This one's
legal
legal.
case is CPS.
DPS?
Yes, so do you have an attorney?
Oh, yes, yes.
All
I
right,
do not recall his name at the moment, but I do have his information in the house.
okay, all right. So you're taking parenting classes?
Yes, ma'am.
What have you learned?
Well, not to leave the kids by themselves for one.
Because one of the children is special needs, and to ask your daughter to be in charge of changing diapers, that's a lot for a child that was her age.
Yes, ma'am.
And then that's nothing worse for children when they're at home and they wake up and all the adults are gone. Okay.
And that, Judge, with regards to that, and sorry to impose, but I think that the drug usage added around this time kind of contributed to making that the most responsible of choices. But I'm hopeful, since he's been staying clean and then he's going to take those classes and be compliant with CPS, that obviously, see the error of his ways.
The fact that he is indirectly blaming his neglect and poor decision on drugs is annoying. I mean, as a parent, you shouldn't fight in front of your kids that trauma was not enough. He went on abandoning these kids, claiming his changed, and all that is fishy.
All right. And so the person that you're hoping to move to Waco with or to Sweetwater with, is that the mother of the children?
No, ma'am.
So you're involved in a completely different relationship with somebody else?
Yes, ma'am.
To make matters worse, Mr. John is suddenly bringing up a new woman to the picture.
This woman I've known since I was 12 years old.
All right. So and this is me just asking because I need to know what your thought processes are. So when did you reconnect with her?
While I was in here in Barry County Jail. The reason I got back in touch with her was because over my life, she was the only one that actually had faith in me and helped me stay straight.
And does she have children?
Yes, ma'am, she does.
And what are their ages?
There's 8 children.
8 children.
Yes.
Imagine him jumping into a relationship with a woman who has 8 children of her own.
So are these adult children or are they all?
There's one that's she's helping raise it. Her cousins, she's 3. Next one is 5. Next one is 8, 10, 12, and the other ones is 13, 17. The other 2 are older. One we consider him a kid. He's actually 26. He's a grown man, but we consider him a kid. This is all not all there,
All right,
but he's not. Only 4 of which are hers.
all right. And then how old are your children?
Mine are 9, 11, and 14. My oldest is 14, but she's up in North Texas. I've actually recently been staying in contact with her. I haven't been in contact with her for over the years because of the fact I was on the drugs. And since I've been clean, I've been building a stronger relationship.
All right, so this is what I've discovered in my time on the planet. Sometimes relationships work out, but sometimes people enter into relationships when 1, they're homesick, they're lonely. 2, they're in rehab, and then they end up immediately moving on and dating someone else. And it appears to the court that you're basing your stability on this person that you've just got in a relationship with.
It is like he's trying to use her financial situation to secure a better life for himself instead of focusing on his responsibilities as a father.
She has a settlement. So she's going to use that settlement to buy property, which means that property should not be in your name. It's going to be in her name, which means she can put you out anytime she wants. She's bringing you into her life. You have these charges, and she has all of these younger children. And then I'm reading the police report. There was an assault case involving the mother of his children that are in this case. And I know that she was arrested. So we have some violence issue going on that the children are witnessing.
Well, Judge Boyd immediately stepped up to make him realize that won't just work. And the worst part is the woman is not even in a stable situation.
So what I can tell you is, at this point in time, I'm not going to let you move to Sweetwater. And let me explain to you why. Because I don't want people to think, oh, I'm just being mean. This is why I'm not going to allow him to do that. At the end of the day, when you're on probation, part of your conditions, these are not conditions I made up. These are conditions from the government, and these are your legal conditions that are automatic conditions. You have to financially support your dependents. And financially supporting your dependents is not depending on this new lady that you've met, who you said you've known for a long time, and depending on her settlement. Because at some point in time, her settlement money is going to run out. And when that runs out, all the issues that you have or that she has are going to rear their heads. She's going to have an issue with somebody not pulling their financial weight.
The best thing he should do right now is set his life straight, focus on getting a job, and ensure his children are safe, not depending on another woman.
That's another thing, Your Honor, if I may.
Yes.
I plan on going up there and getting a better job than I can find out here.
Mhm.
They have better corporations up there that I could actually get a job with.
Mhm.
I have a few applications already put in.
I think your sole focus should be on your children, getting them over this trauma that they've suffered from seeing their parents being violent with each other, and for having their father leave them alone at the house by themselves, and they're waking up and nobody's there.
Him thinking like this doesn't even guarantee that he can be a fit parent, but then all decisions are in Judge Boyd's hands.
So what I will tell you, I consider allowing you to move to Sweetwater once you actually have employment and you've shown the court that you can financially support yourself and that you can support your children, because those are conditions of probation.
Yes, ma'am.
All right. Now, with regards to the fine, I'm not going to impose a fine because you have children.
Thank you, Your Honor.
All right. So count 1 and count 2 will run concurrently. There's going to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days. There's to be no employment as a home health care provider or with minors, CPS compliance. There will be parenting classes and probation. If he's doing parenting classes through CPS, then that will be acceptable. There's going to be 100 hours of community service restitution. I'm going to order anger management classes.
I'm in due to take battery classes.
Oh, with
All right.
CPS,
Yes.
you do, Judge, if he does those with CPS, can he show proof to the probation officer to get credit for that?
All right, probation, if you can see what conditions, well, what the requirements are the battery class, then I'll accept the battery class in lieu of anger management. If what they're teaching there is similar to what they're teaching in anger management. And once that's completed, the community service hours will be deemed satisfied. There's going to be field visits 1 time per month until further notice. We can do a TAP evaluation out of custody, aftercare with lifetime recovery. And where are you staying now?
Castroville.
Casterville?
Yes, ma'am.
All right. Is that a sober living house?
No, Momo.
All right. So who lives there with you?
My fiance.
Your fiance? And do all of the children live there with you as well?
Indeed.
All right. So whose mobile home is that?
Her mobile home and her property.
Is it,
Okay.
is it their?
It's
Medina-
Casterville,
Medina County.
Medina. Just one moment.
Yes, sir.
And is Child Protective Services allowing you to live there?
Yes.
Okay. Sometimes I have no idea what Child Protective Services is doing and the reasoning behind it.
Yeah, I myself don't have too much experience since it's mainly criminal, but I know you have done that civil family law and CPS, so.
But I don't understand why someone, and I appreciate the fact that you're doing better and you're getting your life in order, but I don't understand why CPS would allow someone with these charges to move on property with a lady who has 8 children who are under the age of 17 to just move in, and we have all these other issues going on.
Yeah, Judge, maybe they're considering the fact that he did the inpatient treatment and he's on a plan now. I can't purport to know what their thoughts are, but seemingly they think that he's okay now. He's learning, moving forward and progressing.
I just can't imagine CPS is going to end up placing your children with you if that's what you're seeking, when there are already 8 children in the house.
Not a mouse to feed, yes, I understand.
Judge, Medina County is a reciprocal county to us, so we can supervise. However, because it's not in their county, field visits won't be conducted. If you'd like the field visits conducted, you will do a transfer.
A transfer to Medina? All right, then we'll do a transfer to Medina. What do you do all day?
Look for work. I do a lot of side jobs too.
Okay,
I gotta go to work tomorrow too. Total.
all right. And there's going to be 90 sober meetings in 90 days. Probation, is there anything else?
Okay.
Is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes.
Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. Sometimes when people leave inpatient treatment, real life starts hitting them. And I know these conditions will start hitting you. You need to make sure that you have someone who you can call if you're thinking about using. Don't backslide. Don't, oh, it's just one beer. I had, a hard day. Because then next thing you know, you're completely off track. And if you go completely off track, you know what's going to end up happening? Child Protective Services is going to come in her life and look at whether or not she should have these children in her home. Do you understand?
Yes, ma'am.
All right. If there's anything you need, or you have some issues, let probation know. If you feel as though they're not addressing it, you can always come back to the court.
Absolutely.
All right. Good luck to you. And thank you for always dressing appropriately for court.
Absolutely.
And I'm so happy about your sobriety.
Thank you. I am too.
All right. Thank you. Have a good one. Okay.
Thank you.
Thank you, Your Honor.
Thank you.
You're
Thank you.
dismissed.
Yes.
Judge Boyd is faced with another law offender. The crime of Mr. Damien Huff here is far more serious than that of John Swamy. He was placed on deferred adjudication for burglary of a habitation with intent to commit assault, but then went on to violate his probation rules.
Calling 2023 CR 3681, State of Texas versus Damien Huff. Can I have parties announced for the record for the state defense?
Jay Moritz, Your Honor, from Mr. Huff.
And are you Mr. Huff?
Yes, Your Honor.
All right, Mr. Huff, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes. Your
Are
Honor.
you the same Damien Xerxes Huff who was placed on deferred adjudication in 2023 CR 3681 for the offense of burglary of a habitation with intent to commit assault on July 26, 2023 for a period of 4 years? Is that you?
Yes, Your Honor.
All right, state.
Your Honor, the state is going to be going to have
Well, what motions are you proceeding on?
we're going to be proceeding on violation of condition number 19.
All right, if you would read that violation, please.
Yes, on or about the 10th day of June, 2024, Bexar County, Texas. The defendant, Damien, is then and there failed to attend alcohol and drug evaluation. The approved agency TAP BCC in violation of condition number 19.
How do you plead to that? True or not true?
True.
And the other allegations?
We will be waiving all the.
Any objections to the state's waivers?
No, Your Honor.
Mr. Huff, did you understand by pleading true to violation of condition number 19, the court could find it true, grant the motion, sentence you to 20 years in the prison and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition 19?
Yes.
Court will find violation of condition 19 true. Is there a proposed agreement? And what is the proposed agreement?
Honor, with follow working conditions from probation and dependent on probation, with all the conditions remain in full effect, and then also have a TAP evaluation while the defendant's in custody.
And defense, are you in agreement?
Yes, Your Honor.
Probation, is this your agreement?
Yes, sir.
All right, you want to raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Damien Huff.
All right, so why did you miss your TAP evaluation?
Just stuff was happening in my personal life.
It's outrageous that Mr. Huff chose to refuse to attend his treatment accountability program and is even blaming it on his life crisis.
And I just really wasn't ready, I guess, or I couldn't attend to it. So I just slipped further into my substance abuse, I guess.
I'm sorry, what?
I just slipped further into like depression and not continuing forth.
The audacity to just fall back into drugs after the severity of his crime is wild. Just because things are working out in your life doesn't mean you should do drugs, so this excuse right here is completely lame.
With what I was supposed to do.
All right, so let me explain something to you. You have to make time for probation. If you don't make time for probation, then the next question is, do you have time to make time for prison life? Because on this case, and I'm trying to stress to you, on this case, you're looking at 20 years in prison. And a lot of people will come to me and say it's just marijuana. But in Texas, marijuana is not legal. And in Texas, you're not allowed to use marijuana unless you have a medical prescription for marijuana. And it's approved by probation. Do you understand?
Yes.
Well, Judge Boyd didn't even buy his weak excuses and called him out immediately on the consequences of his actions.
So anytime you're thinking about not doing your conditions of probation because you don't have time and other things are happening in your life, just think about the fact that you will make time for 20 years in prison potentially. Do you understand?
Yes. Yes. Your Honor.
All right. So what has been going on in your life? You said other issues.
Yeah, just personal, like with my mother and stuff, like at home.
All right. What's going on at home?
They're just foreclosing on the house and everything, so that kind of was up in the air, like where to stay and everything.
All right. So how old are you?
29 years old.
All right. So you're going to have to find a place.
Yeah, definitely. And that's I've had that like in like I've been on my own since about 17, and just happened when I was like 27. So I moved back to my mom's and to see this through. And then yeah, they just came to foreclose on the house for 30 grand. So that kind of just put me in an odd spot when facing homelessness and other things like that.
All right. Well, I will tell you, usually in situations like that, they want somebody to pick up the phone and talk to them. Because sometimes it's not a buyer's market. And maybe you could talk to them and see what can be worked out. Maybe something can be worked out, maybe not. But the key is not avoiding.
Yeah, definitely.
And that's what probation is about, not avoiding. Just pick up the phone and call probation. You could have called them and said, hey, I know I have a TAP evaluation schedule, but I'm having issues with my living situation at the moment. Foreclosure is happening. Can I reschedule it? And I am telling you, I believe they would have said you can reschedule.
Yes.
It's obvious his lying about his family issues as a reason for not showing up for probation, because if he truly wants to show up, he would, or better still, as Judge Boyd said, he would call the probation office, but no, he just doesn't want to work on himself.
All right, the court will follow your agreement, deny the motion, alter and amend conditions to include TAP evaluation in custody and follow all TAP recommendations. And probation, is there anything else that he would need?
Maybe possibly a felony drug court now.
All right, we'll do a referral to felony drug court, and that will be in custody. Because it's Tuesday, felony drug court will probably be able to see you this week, and you need to be honest with them, okay? And is there anything else that you need from the court to help you be successful on this probation? Like any mental health issues, any other issues you may have?
No, I pretty much understand.
All right, and probation, if for some reason foreclosures happen and they're evicted, See if you can do a referral for him with that organization, Building Better Communities. And that's an organization that can help you at least find affordable housing, okay?
Any sane person in this situation would focus on reaching out for help during a tough time, rather than choosing to avoid his responsibilities using unreasonable excuses.
All right, if there's nothing else, all right, good luck. We can go off the record. If something comes up and you need something, let probation know. If you feel as though they're not addressing it, you can always come back to the court. You understand?
Yes.
All right, good luck to you.
Thank you.
You're welcome.
Have a seat, sir.
Just for clarification
Yeah.
for me, two things. Once he does a tap, then they release him? Is that a?
No, he will have to do a referral to felony drug court as well. I think felony drug court will probably happen sooner than the TAP evaluation. TAP evaluation is 2 weeks. Now, if he's not accepted in the felony drug court, and if the TAP evaluation recommends that he do inpatient treatment.
Finally, this last case is focused on Mr. Choppa charged with stalking, classified as a third-degree felony. The potential punishment range for this offense is 2 to 10 years in prison and up to a $10,000 fine. Stalking isn't just some minor offense that should be ignored. It's a serious crime that puts the victims in danger and constant fear.
Yes.
Family violence is not here. I'll stand in for them.
All right, thank you.
Made a little bit of information about this case design,
Yes.
not brief.
All right, I'll walk you through it, State. All right, court is calling 2024 CR 007969 State versus Daniel Choppa. Can I have parties announced for the record for the state
Andrew Harris, Salem.
defense?
Catherine Valenzuela.
And are you Mr. Choppa? All right, you're gonna need to speak up so that I can hear. You're listed on the docket as Choppa and Maestas. Yes, so is that your,
It was my last name till I changed it to my father's name.
okay. And was that
Choppa.
changed legally?
Choppa is-
Huh?
Did you legally change it? Did you go to a court? All right. All right, counsel, have you received all of the discovery? Did you review it with your client?
Yes, Your Honor.
Did you, Mr. Choppa, review the document titled Application for Community Supervision with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
I do, Your Honor.
All right, state, it appears that you are proceeding on count one and waiving the repeater offender enhancement allegation. Is that correct?
Yes, Your Honor.
It is, Your Honor. And just to be clear, there is only the count one in the indictment,
No, there are 2 counts.
and we waive count two.
All right, thank you. Any objections?
No objection, Your Honor.
All right, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Did you understand you're charged with stalking as a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, he has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he was.
Mr. Choppa, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, the state is proceeding on count one. Punishment is to be assessed at 10 years in the prison. There's no application for deferred adjudication. State recommends community supervision. This will run concurrent with 2024 CR 0270, which is a misdemeanor. The state will take in consideration 2024 CR 007970 and night mag number 764573. Did you understand that to be the plea? Did you understand that to be your plea bargain agreement?
Yes.
Defense, is that the plea?
Yes, it is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counselor, there be any such motion?
There have been no such motions.
Outside the agreement, the state is recommending that your community supervision be for a term of 6 years and there be no contact with Elaine Rodriguez. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, sir.
Then to the offenses charged in count 1, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Should be contained in exhibit 1 and attachments, Your Honor.
My client and I have reviewed states 1. We have no objection, Your Honor.
All right, did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court going to find there's sufficient evidence to find you guilty, and the court will find you guilty. All right, so defense, why should I follow this agreement?
Your Honor, Mr. Choppa has been placed, he is currently on probation on the other case. He's been in, that happened a month ago. He has not been released, so he has not officially been on probation, but he is, the court granted that. In addition, Mr. Choppa has been in custody for 5 months. During this time period, he had been diagnosed prior with mental illness.
Well, as usual, they all have an excuse for their crimes, and Mr. Choppa isn't an exception. He is suddenly trying to justify his actions using his diagnosis as an excuse.
He was not compliant with his medication at the time of this offense.
What mental illness?
Will you tell the court what your diagnosis was?
Bipolar, schizophrenia.
So it's bipolar schizophrenia. I don't know if you heard that, Your Honor. So now he has been on medication since being in custody. He's now compliant with his medication. I think he has a new framework on how he's thinking of things, and we believe that he would be successful on probation. In addition, on his misdemeanor probation that you granted, you placed him on GPS, only allowing him to work. We believe that he will demonstrate to the court that he can comply with that. We are going to be putting a motion in for waiver of fees for right now, since he's been in custody for 5 months and he has not been able to work.
All right, so I understand he's bipolar and schizophrenic according to him, but why does his bipolar and schizophrenia only result in him having issues with women?
The crazy part here is that his so-called illness is just centered around women, but we know Judge Boyd isn't going to fall for this.
Why are there no charges? Not that I'm recommending, but why are there no charges against men? It appears that he only has issues with women. And I do see that this offense occurred prior to the offense that he's on probation for, I believe. Let me see. No, actually, what he's on probation for occurred after this incident.
There were a lot of cases and we've been trying to dig out. That's why we've done this piecemeal and not at one time to figure out what are the actual charges and when they have come forward from the office. But I do believe that Mr. Choppa is coming before the court and asking to be placed on probation and willing to abide by the conditions imposed by the.
The audacity for him to request probation again is something else. I mean, we know the majority of these offenders just throw away their second chance, judging from how he is already dodging accountability, blaming his actions on bipolar and schizophrenia.
I mean, there are a lot of conditions on the misdemeanor, on the other probation, and we believe that these could run concurrent and he would be successful. And he does have family support now, a very active sister and others who have older daughters also who have indicated a willingness to help him.
All right.
Now that he's helping himself.
So, Ms. Abrams,
Yes, Judge.
the case that he's on probation for is a misdemeanor.
Yes, Judge.
That misdemeanor case occurred after this case, and before this case. And he was granted probation on that case. And my understanding from the plea previously, that family violence said that the complainant was aware and was in agreement with his previous plea, I believe.
Yes.
All right. Court is finding you guilty. The court is going to sentence you to 10 years in the prison, suspended and probated for 8 years.
Judge Boyd saw through everything he was planning and found him guilty as charged.
This is to run concurrent with 2024 CR 0270. Taking consideration 2024 CR 007970, night mag number 764573. There's to be no contact with Elaine Rodriguez, and that's Elaine with an E. And when I say no contact, I know you haven't had contact with her since you were placed on probation in other case, but when I say no contact, that means no contact. That means no, I apologize. I've got my life together. I just want to send you flowers to say, I'm sorry. Yeah, there's to be no sorry or any of that. Do you understand?
Yes.
If you contact her at all, that's a violation of your probation and you're looking at 10 years in the prison. You understand?
Yes.
And it's probably best for you that you not enter into any relationships until you get yourself together. And when you enter into a relationship, make sure that that person is not meeting your publicist, they're meeting you. What do I mean by that? You tell them about all this stuff that you've done. And then if they still want to be with you, then great, they're on notice. But if you are dishonest and then they end up finding out about this, that's going to cause an issue for your relationship. You understand?
Your Honor,
Yes.
apologies for interrupting. Did I hear you say correctly that you assess Mr. Choppa's term of confinement in 10 years?
Yes.
If I'm looking at the plea bargain agreement correctly, punishment is to be assessed at 6 years.
No, 10 years and 6 years probation.
Yes.
That was the paperwork. said
Yes.
10 years.
Okay, I'm sorry.
I am looking at the wrong paperwork, Your Honor.
All right, thank you, Mr. Edelman. So there's no contact with Elaine Rodriguez. Proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors. And standing in for the state is?
Raymond Saldana.
All right, and Mr. Saldana, did you have contact with the complainant?
We have.
And is she aware of this plea bargain agreement?
She will be.
Okay, all right. And she's in agreement?
She. Depends.
No, she had been, I mean,
She
she had been prior. to
Okay.
this. Yes. I'm
All
sorry.
right, there's to be regular reporting by Zoom or in person, regular random UAs, anger management course, 150 hours community service restitution, referral to Center for Healthcare Services, MIC evaluation in custody, gang evaluation in custody, field visits, 1 time per month for 3 months. Probation, is there anything else? Is there anything else you need from the court to be successful?
And Your Honor, so on this case, there is no, I'm not trying to impose conditions on him. There's no GPS on this case.
Well, thank you very much.
Yeah, that's why I was afraid.
Calls ending in 0270, we do have partial GPS for
Yes.
purposes only until further notice.
Well, the only thing is that case, his probation is only for a limited amount of time. I think his probation is for 2 years.
Correct.
All right, we can keep the GPS on for that. And then if there are some issues, we'll see about adding it to this case.
Like, so Judge, do you want the fees waived or anything for that?
Yes, the fees can be waived on the GPS. All right. Is there anything else you need from the court to be successful? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right. We can go off the record. In this court, to be successful on probation, communication is key. If you need anything, let probation know. If you feel they're not addressing it, you can always come back to the court and address it with me. The other thing, make sure that you follow the conditions that I've set for you to the letter. Do you understand? All right, good luck to you.
Thank you, Your Honor.
You're welcome. Oh, and Raymond,
Yes.
on the night mag case, do you guys have the dismissal for that?
We don't. I'm gonna let intake know so they can reject that case.
All right, thank you. Vanessa Boss, Norma,